Hello to all our viewers. Just to recap, I'm attorney Stephanie Garces-Donay, founding partner of Garces Law Firm in Arlington Heights, Illinois. Welcome to Pink Mike Legal Confessions, where we talk about things that you care about. At least we hope that by the time you leave this show, you actually know something that you didn't know before you got here. All right. So we at this firm help parents secure their legacy, protect their children in the expect of an unexpected absence. I always say we prepare you for the unexpected because, as we know, there's always unexpected in this lifetime. So when you think about creating a legacy and protecting that legacy, this includes a will and a trust, maybe life insurance and retirement. Really just depends on a number of things that you're thinking about. But for this week, we're actually going to be covering something that's really important. And we're going to be talking a lot about primarily guardianship and what it means to actually have a guardian in regards to your children and how to protect them. And so one of the things that I would like to discuss of the many things is that we have different ways to protect our families. And one of them for all of the parents out there is in regards to essentially protecting your children in the event that you're no longer here. And so we're going to talk a lot about how to properly select guardians for your minor children. And hopefully today you get more information about that. And today I have the pleasure of having one of my colleagues, attorney Christopher Nudo, to address one of the most popular discussions that I have with parents, and so does Chris. And so we're going to talk a lot about how to select a proper guardian for your minor children. And with so many people having children, especially during a pandemic, growing families is always a theme in everyone's life at some point. And so it's essential to have the proper guardianship paperwork in order in the event of an emergency. Chris, can you please kindly introduce yourself to all of our viewers today?
Hi, Stephanie, and thank you for having me. So I've been an Illinois practicing attorney for just about 30 years now, and my practice focuses primarily on estate planning, probate, real estate, corporate law. I've represented a lot of churches and charities over my time, and all in the northwest suburbs of Chicago.
Great. Thank you for joining us, Chris. We're excited to have you. I've known Chris for a very long time at this point. So all of our viewers, be nice with your questions. Don't be too complicated. No, I'm kidding. Chris is the very experienced in what we're talking about today. So he's going to share some really, really great insights. So thank you, Chris, for introducing yourself. Now, kind of a couple of objectives here, just so you understand what this is about. Now, really what we're hoping to encompass today is a couple of questions that you have, and perhaps even some sort of theme to this topic that you may think about your questions as you proceed with us. But we're going to cover a couple of things. The first one being, why should minor children have a guardian selected? We're going to address that a little bit later on the show. The other one is what to consider when selecting a legal guardian, and who should have custody over your children in the event that you're no longer here. And lastly, what legal documents do you need to have in place in order to do that? And so I've saved some time at the end to address these questions, but please go ahead and enter your questions down below in the chat so that you can have your questions addressed. Now, I know a lot of parents are out there and they're watching, and perhaps even some parents that are expecting a baby. This is relevant to you as well. We will touch also on disabled adult children, which Chris recommended that we add to the show, which I agree with because this also is very relevant to individuals that have disabled adults in their family. And so kind of just to recap really quickly, if you're just joining us now, as I mentioned before, thank you to all our viewers for checking in today and for sharing the video. My name is attorney Stephanie Garces-Donay. I'm the founding partner and the principal attorney of Garces Law in Arlington Heights, where we help parents secure their legacy and protect their children in the event of an unexpected absence. So Pink Mike Legal Confessions, Facebook Live. Today I have attorney and a good friend of mine, guest Christopher Nudo, to discuss some of the topics we're going to talk about regarding guardianship. So Just some housekeeping items. In the event that you missed last week's show, we covered life insurance and retirement planning. You can always watch on our Facebook page. You could always watch on my YouTube channel if you are so inclined to do so. Don't forget to subscribe for that as well. So we welcome you to join us here every Tuesday, 2:30, Pink Mike Leo Confessions, where we share tips for parents, for guardians, and the like. Now, I know a lot of you may have some questions, but as I mentioned, please put your questions down below and we will address them accordingly. For those of you just joining us, we are discussing how to select proper guardians for your minor children. Okay, so we do have a question from the audience now. Chris, are you ready? Because it's coming. You're ready. Okay, the first question we have today, maybe one that is relevant to some of the questions we get as attorneys, but what should I do to avoid, I'm going to say that again. What should I avoid when choosing a legal guardian for my children? Chris, what do you think?
Well, first of all, I love the question. I kind of want to spin the question around, though, because the question is phrased in the negative. What things should I avoid? And so why don't we talk about the things that we should consider when picking a guardian, and that will clearly outline the things we should avoid. First of all, when considering a guardian for our children, we want to find somebody who really mirrors who we are as parents. And so we have to really do a dive into what kind of parents are we? What type of schools do we want our children to be raised in? Is that a public education? Is that a private education? Other things such as church affiliations. And it's not uncommon in these days for the same family to have many different religious views and different church affiliations. And so it's very common in my practice for parents not even to name other siblings as their guardians, but yet best friends, because we find that their lifestyles mimic their parenting choices closer than their siblings do. Also, while you would think that religious views and church affiliations go hand in hand, they can differ greatly. And so your guardian should not only share the same values with regard to your church, education, but also those religious views within those contexts. And finally, things that are really important to consider is how does your family see itself when it comes to money, when it comes to college education, when it comes to children working, and at what age is it appropriate for them to start working? Other considerations are your how much should your child contribute towards their own college education? These are all value questions that I ask my clients to consider when they're thinking about who they want to name guardians for their children. So let's go back to your question, Stephanie.
Mm-hmm.
And that is, what items should we avoid? Well, we should automatically consider the fact that our siblings, our brothers and sisters, may not be the perfect choices for raising our children. Also, parents who are our parents shouldn't always be our first go-to. While they may have raised you just fine, they likely are getting old in years and may not have the energy or patience to raise their grandchildren. They might absolutely think they can, and they would love the chance to do it, but we know that they may get tired quickly and may not have all that it takes to be good guardians. So those are just a few things to consider when choosing and avoiding who you would pick for the legal guardians of your children.
Yeah, and I love that, Chris. I mean, those are very solid points, and thank you for explaining those points so eloquently. I think you bring up a good point, and I think at least to me, I don't have children yet, so some of our viewers do not, and these are things that we think about in our lifetime. Chris, you obviously have children, so it's one of those things where you brought up a good point. Do we think our siblings are good? And sorry, brother, if you're watching this, I don't want to offend you, but it's one of those things where you think about it like, do I want my sibling to take care of them? And also, quite frankly, I think you bring up a good point. I love my parents dearly, but depending on their age and depending on their lifestyle, is that the way you want to bring your kids up? And those are great questions. So thank you for answering that. We're going to take another question that we have. A viewer is asking, are there ever situations when guardianship would override parental rights?
Okay, that's a really great question, super complex.
Mhm.
And so we're going to try and make it very simple. And we're going to start with the simple answer with no, but sometimes. So how about that for a legal answer?
That's like, it
Do
depends.
that. Right. It depends. So the idea that a guardianship would overrule a parental right is extremely, extremely rare. Parents, whether married or divorced, have first right. And I get this all the time when I have clients come in who are divorced, and the husband doesn't want the mom to get the kids, or the mom doesn't want the kid to get the kids, and vice versa. Reality is they're probably both pretty decent parents. They just couldn't make their marriage work, and the children are the children of both parents in my example, and their parental rights overrule any guardian that is recommended by my client or the person who is picking their guardian. Now, there are instances where parental rights are terminated. And in those instances, through those very unfortunate circumstances, which are only done through court proceedings, a guardianship would overrule parental rights. But again, that is not the norm. That is for sure the exception.
Yeah, definitely. And I think kind of how we've just kind of described this through many Facebook Live series, we've always said really depends on the circumstances. So, if you have questions about that in your particular case, feel free to reach out to Chris or to I, because we are both here to help address those questions. Everyone's situation is different. So it is not a one size fits all. And Chris is right about that. So thank you for answering that, Chris. Okay, so here's another one we have, kind of an interesting question. How old do you have to be to choose your guardian? So perhaps that is a question for if somebody is looking to choose a guardian, and how old do you have to be?
Okay, so again, audience has some pretty interesting questions here. I love them, keeping me on my toes. So, how old do you have to be to choose your guardian? There is an assumption in that question
Yep.
that, and the assumption is that you get to choose your guardian. And in most cases, guardians are chosen by parents. So you have mom and dad who are adults, and you have children who are under the age of 18, and something tragic happens to the parents and they pass away before the children become 18. And the parents are choosing through their will guardians that they would like to recommend to raise their children. And in those instances, the recommendation to the court is going to be what the will states, which is what the parents um, have designated in their wills for guardians for their children. Now, back to your question. And sometimes we'll have children who they're not adults yet, but they are well into their teens.
Yep.
They think they're adults. And they uh, definitely will have an opinion about who they want to raise them. Would it be Uncle Jim, Aunt Sally? And if those are the two people that mom and dad have identified, The court may ask these teenagers, do they have a preference? But by no means are they able to choose who's going to raise them. But the
Right.
court would definitely listen to what their opinions are. And if their opinions are based on some solid decision making, some wisdom in their thoughts as teenagers, the court will definitely consider those factors. Um, However, let's just kind of talk about teenagers and what's important to them. If Aunt Sally is chosen because we know she makes the best brownies, and that's the criteria the kids are using about who they want to go live with, the court may weigh some more substantive matters about where the house is, what schooling's available, who's more in a better shape to be able to raise the children, instead of taking the opinions of the teenagers.
Yeah, that's a great point. I love brownies, but I guess, it's not the best criteria. Okay, so kind of scaling back, because I think we're getting into the weeds for some of the viewers. I know we kind of talked about this briefly before the show, Chris, but, you and I have very strong opinions about why this is needed. Why does someone need to pick a guardian for their children? And a lot of our viewers do not even have a simple legal document. And we say simple because it's something that Chris and I can prepare pretty easily for you guys once we have a consultation with you, of course. But just kind of the basics, what legal documents are required to designate the guardian. And that's kind of what I wanted to touch on. And in addition to that, why should people have it? Now, and I know you and I know the answer to that, but for our viewers who are looking to perhaps think about this more, why is this important to them?
So let's start with the document, right? The document that identifies the preference of guardians that you would like to make for your children is a will, a garden variety will. And there are many, many, many types of wills. And Stephanie and I would be just nerdy enough to want to talk about all the different types. But for purposes of this show, we're talking about just your garden variety simple will. And it has a provision in it for guardianship. And you may ask yourself, well, why do I need that? Wouldn't there be somebody who would raise my children if I didn't have a will? And the answer is yes, there is. But let's talk about why you might want to have a will that specifies the guardian. If you don't have a will and you and your spouse die, leaving minor children, then you're going to have a potpourri. Let's hope you have a potpourri of people fighting over who want to raise your children. This could be friends, it could be parents, it could be siblings. And there's no direction for the court as to who is best suited to raise the children. And no offense, you've passed away, so you can't give your opinion to the court as to whom you would choose. That time has long passed. That is why we would recommend that you prepare a will ahead of time, so you can give the court who you would prefer to raise your children, and we can put that in a sequential order so that if one is not able, then the next one would be the one that you would choose. Often with young parents like Stephanie, it would be not uncommon at all for them to choose their parents first. But as Stephanie ages and becomes an old fart like me, then you wouldn't want your parents raising your minor children. Rather, you would want somebody either my age or younger who would have the patience to do such a thing. So that's why, to answer your question, a garden variety will is the document. And the reason we do it is so that it minimizes the court interference and fighting among people into whom would raise your children.
Great explanation, Chris. And actually, I get a lot of this question for a lot of my potential clients. One of the main ones is what you touched on earlier, is by saying to me, well, do I really need anything in writing? I mean, they do have godparents, they do have such and such person, but as you said earlier, there's an assumption to that, correct? There's an assumption that that person is going to be available, and living. and B, that they would want to, right? Because what if their lifestyle changes or something happens to them and they're not available to do it? So thinking about these things are really important. So thank you for kind of giving us a synopsis of that. We do have another question from the audience. I think it might be in regards to what we sort of provoked it thought about is parents that disagree. This is a great way to kind of address this question. So I'm going to read it. One of the viewers is asking, my husband and I are divorced and we want different guardians for our children. So how do you recommend we handle this? That's a
great question. That's a good one. That's right.
Yes.
And that is a question that I would say almost 100% of couples that are divorced have. Like, that is like a mainstay.
Yeah.
First of all, let's remember that even when parents are divorced, mom and dad are still mom and dad of the children. So if dad passes away, the children are going to mom, even if mom doesn't have custody, and vice versa. Meaning if mom has custody and she passes away, them kids first go to dad. And there's no debate over this,
Right.
unless for some reason there's question as to the fitness of dad, which would go towards his parental rights, which, again, too far in the weeds for this conversation. So very common. Mom would do her will, and she would identify who she would want to be the guardian should dad die, and vice versa. Dad would put in his will who he would like to have the children raised by if both mom and dad should pass away before the children turn 18, regardless of their marital status. And people ask, well, then who would win? And because mom named somebody different and dad named somebody different. And the answer is simply the survivor of mom and dad, whose ever will is second, would be the recommended guardians to the court. So if mom passed away first, dad passed away second, it would be dad's will and his recommendations. And of course, if dad passed away and then mom passed away second, it would be mom's recommendations.
Mm-hmm. Yeah, this is a great question because, again, a lot of people do ask that, not just for divorced couples. Really, we're going to talk about couples that are just not together. They're separated as well. These topics become very relevant. And so I know, Chris, maybe, do you ever have a client that kind of gives you this scenario and says, absolutely under no circumstances do I want my child to go to their mother or my child to go to their father? I mean, do you kind of give them the same spiel? Because I do get this question a lot, and it's always, the same answer, but not everyone likes the answer,
Yeah. Well, they don't like their ex-spouse, is the reality.
Yeah.
So yes, of course. You and I get the same questions by every couple who is not living together as a result of separation or divorce. And, the answer is simply, you may not agree with their fitness to raise the children, but the court has already made a determination to some degree with regard to custody. And so while mom may not think that dad is capable and dad may not feel that mom is worthy, those opinions are probably not based in fact, but based on strong emotional decisions. And so the reality is nothing about the divorce terminates the parental rights. And so in the event of one parent's passing, the surviving parent is the default person for the children to go live with.
Great. Yeah, I agree. And that's kind of what I wanted to touch on, because again, we get a lot of these questions, and there is rights that each parent has. And so, not always can the will trump those rights, especially if that person is still living. So unfortunately, I'm sorry, that is not the answer everybody wants to hear, but that is the correct answer. So, and I know, Chris, kind of to dive into a little bit more in that, we talked initially, before the show and at the beginning about disabled adult individuals, and this is a topic that some of our viewers may or may not resonate with, but for those of our viewers that it does resonate with, how is the will protect in a disabled adult in the event that that is something that is relevant to our viewer?
Yeah. So a simple picture clears this one up real easily. So when you have a disabled child, and when I say disabled, typically we're talking some form of cognitive impairment.
Mm-hmm.
And what happens is, if all goes well, those children live a fruitful life despite their disability. And at some point, they become 18 years old. And with a child who is not declared disabled at 18, they are treated as an adult and guardianship is no longer a consideration. However, many people have disabled children, and when that child turns 18, the fact that they've become 18 doesn't immediately give them uh, all of the same uh, abilities to live life and freedoms that people without the disability have. So, this is where a guardian is very important. As a matter of fact, even during those children's lives after they've turned 18 or older, the parents typically become the guardians of those adult disabled children. And so it's very, very important that if you have a disabled adult child, that you have a will that specifies who should care for that child, just no matter what their age is, because in these cases, they probably will need type of assistance from guardianship for the rest of their lives.
Yeah, definitely. And kind of going off of that, we had another question, kind of a spin-off from that is there anything else I can do to protect my disabled adult child, when they turn 18, aside from the will, whether that's another legal document, I think is what they're referring to, or if there's anything extra. And I know we talked about the rest of their lives, and this might be going into another topic, but just to address the viewer's question, what are other things to consider outside of just the will?
You know, I think the conversation would spin too far into the weeds
Mm-hmm.
to start talking about a disabled adult children and guardianship and the requisites and the whys. However, I would say this: if you have a disabled adult child, or if you have a disabled child who yet is not 18, we strongly recommend that you consult an attorney and find out what steps you need to take once that child does turn 18. I will tell you that Cook County and all of the surrounding counties of Cook have very, very friendly guardianship courts for parents in these situations. A lot of times, parents don't even need to hire attorneys to go in and take care of these types of things. It might be a little more intimidating during COVID here and the need to um, learn all these things via Zoom. But I'm confident that a young parent who's digitally savvy could navigate these waters. And of course, attorneys like Stephanie and I and many others are quite capable of assisting if necessary. But the will is the document that should be in place to appoint guardians of your disabled minor children. We don't want to talk about anything else. We just want to make sure that people have your garden variety will in place at a minimum.
Great. And kind of a follow up to this question, someone had asked in the chat, is there a way to revise my will in the event that I change my mind about the legal guardian? Which is a great question, because I think that many people get concerned that once you fill out the document, you get it notarized, it's final, and it can't be revised. But I believe that is a myth. That is not true. And Chris, you can elaborate on that if you'd like.
Yeah, I think there are two great myths in this regard. The first one being that once I do my will, it's like etched in stone, and that is not the case. A will can be changed at any given time. Now, here's something that's really important. You cannot, or we would advise that your audience members do not try and amend their wills themselves.
Mhm.
It is very common and unfortunate because a lot of people will take their wills and they will take the provision that they don't like and they will scratch it out. They will write in there what they want, and then they will initial it thinking that this is like some contract provision that is being changed and modified. And the fact that they scratched it out neatly and put their initials by it somehow makes it official. And what you've actually done when you've done a modification like that to your document is you've voided your will, meaning now the entire document is of no value. So while we can change a will as many times and as often as you want, and it is not etched in stone, when you do it, please make sure that you get with somebody knowledgeable who knows how to properly amend a will and amend it appropriately.
Great. Yeah, that is a great explanation, Chris. And I think that is a common misconception about wills, that you're right. It's etched in stone. And actually, I've had people come to me and say, "Oh, I revised it because I got angry at my daughter. I got angry at my son, so I changed it." And so, folks, if you're listening to this, please consider talking to a legal professional like ourselves to set up an appointment. You see the number below. This is my office line if you want to text or call us to set up a consultation, because one of the things that we want to do is we want to advise you properly, because once you're no longer on this earth, if you've made revisions to this will and unfortunately have invalidated your will, essentially, there's really nothing else we can do to try to undo what's been done. So to prevent all of that, it's better for you to sit down with a professional, make the proper revision. It doesn't cost an arm and a leg to revise, I promise. I know a lot of people have questions about that. So with the intention of, we should be looking at our wills and revising them accordingly. And Chris, I know one of the questions I always get, I know during the consultations, which, by the way, we do offer free consultations from the safety of your own home or in person if you'd like. But a lot of the stuff we are offering is virtual. So if you do need a consultation with us, please let us know. We'd be happy to accommodate you one way or another. But kind of going off what I was saying, so I do get a lot of questions about will revisions and when is a good time to check in with the will. And this just expands not just for legal guardians, because you may have changed your mind about that, but perhaps, you have more than one child. Maybe I made my will when I had one child, and then 2 years I have two more children. So when is a good time, do you think, in your professional opinion, to change the will or, revise it or do something to sort of check in? Because a lot of people, they make it, they throw it in the corner of the house and never look at it again. But I want viewers to understand, when is a good time to look into this again, revise it, make sure it's has all the accuracies and all your intentions set forth. So when is a good time, Chris, in your opinion?
Yeah, so a lot of lawyers recommend time periods. They say, call me every 3 years, call me every 5 years, and check in and let's revise your document. However, that's not what I recommend. I am a proponent of revising your will and your other estate planning documents upon the changes in life events. So let's talk about those life events and those times where you should consider your estate planning documents like your will and whether or not you should revise them. First, marriage is a big life event. Second, each time you have a child is a major life event. Buying your first house, selling your first house and buying your second house. These are major life events. When a child, when your children have graduated high school and are going off to college, that is a major life event. And other life events are people that you've named in your will, like you named your brother, your sister, and your best friend as executors of your will, and you named your best friend and your sister as guardian of your children. If for some reason those relationships should suffer and not be as strong as they were when you drafted your will, that would be indicative of a life event in which you should look at your will and consider revising it. So I don't tell my clients a certain time frame. I make them conscious about what different life events there are that should trigger them to review their will.
Yeah, great. I mean, I've actually talked about life events on Facebook Live, Pink Mike Legal Confessions, many times, because you're right, Chris. I think if we assume as attorneys, every 3 to 5 years, that might be a good time. But then again, things change so quickly. Like I was saying before, a lot of people are planning their families, and they do have a set time frame, whether that's every year, every other year, to have more children and whatnot. And actually, kind of going off of that, one of the things I wanted to address for our viewers is we're not just talking about children that you have. There is ways if you adopt a child to also for this to apply to you. And again, kind of the adult disabled children or a disabled child, this is also applicable. So I just want the viewers to understand that it's not just people that have biological children. Children can be adopted. They could be your biological children. So just keep that in mind as we kind of talk about this, because I don't want anyone to feel left out. Because a lot of times people will say, oh, you didn't cover this. Well, we are trying to all encompass this, all together. And, we talked about revising your will, very important. And one of the questions that just came in is about if I live in another state, but I want a will, can I get any attorney in any state to draft the will?
Great so question. Again, a really good question, Stephanie. Yeah. You got a sharp audience, let me tell you. The answer is yes. The nice thing about wills is they really do cross geographic lines nicely. Now, I would recommend that if you lived in Illinois, you have a will prepared by an Illinois lawyer. If you live in Iowa, you get an Iowa lawyer to draft your will. But wills have been around since the cavemen. And by the way, back then they were etched in stone. And no, I was not one of the original cavemen, Stephanie. I know you're thinking that. But
when you said caveman, I was thinking like a little guy like writing out, my exact
for sure
will be such and such. Okay, go ahead.
All of that said, because wills have been around for as long as they have, wills are fairly the same, almost identically the same in all 50 of our states. And the nuances between the 50 states tend to be minimal, like meaning a will from California will work in Illinois, which will work in Louisiana, which will work in Alabama, and still even crazier in Wyoming. Now, all the terms within the will be different, but because wills have been around so long, even the different jurisdictions will understand the nuances in wills that were prepared in other states, and they will not be invalid. Again, I don't recommend that. I recommend that your will is prepared in the state that you live. But if you have a will from a different jurisdiction, it should not be a problem.
Great. Yeah, that is a great question because some of the viewers are from across state lines. And also because people do rearrange their life, I have a number of people that say, oh, I want a will, but we're moving to Florida, in the next year or something. So you may consider what we're talking about today about getting the right advice, because again, there is no harm, no foul in revising your will as you proceed in your life. A life event would be moving out of state. Life event, having a child. We've kind of already talked about this, but this is just the kind of stuff we want to provoke thought for our viewers so that they don't feel like, they're stuck in their will made by that one Illinois attorney when in fact, you may need someone in Florida because that's where you're living. And so you do have to check in with this stuff. Do not sleep on this, because if you do, you end up regretting it. Well, you don't, but your family does because you're no longer here. So that's like an estate planning lawyer joke. So kind of going off of that, one of the final questions we have here, which is kind of interesting because I think Chris and I, we talked about this before. The children, can children pick their legal guardian, whether they're between one person and another? You kind of talked about this, but I think this also assumes, if I'm not mistaken, that the children have power. And so what we're trying to convey here for a viewer that asked that is that creating a will gives power back to the parents. It gives power back to the parents because, again, it sort of trumps anything else that anyone else could say when you're no longer here. So kind of asking that question, maybe the viewer came in a little bit later, but it's still a question. Can a child pick between two guardians because they're picking between, nice aunt and mean aunt?
Right. And, like we said previously, the children really don't get to pick their guardians.
Yeah,
Let's not mistake the fact that they can, in some way, influence the court.
right.
Um, if they are making, if they are making their decision based on an argument that they would consider to be in their best interest and it is presented appropriately to the court, um, for sure they would influence any decision that would be made. And a great illustration would be um, uh, Aunt Millie is willing to come live at mom and dad's house so they can stay in the school district that they're in, and going to live with Uncle Robert requires them to have to move to Long Island, New York. And right now at their stage in life, staying in their school district makes more sense, despite the fact that mom and dad really wanted the kids to go out to Uncle Robert in Long Island, New York. Aunt Millie, if what makes more sense, because she's willing to disrupt the children's lives less than Uncle Robert is capable of doing. And that's an instant where the kid's the kid's opinion would influence the decision of the court.
Yeah, definitely. And I'm happy to hear this because, one of the topics we don't talk about is what children get to say in the interim of all this, because sometimes, like Chris is right, some of our viewers, you may know your children, they're strong-willed. They have a very strong opinion about X, Y, and Z. And of course, they somehow have a little bit of power in that they can make arguments in their behalf. But at the end of the day, the court is really who decides that, if it were before a judge. Now, if the question was addressing, you creating your will before you're before a judge, in general, the answer is no. Your child cannot come into our office and say, I demand that I do this and you do that. Chris, what would you say if a kid said that to you? Would you say, how old are you?
Actually, I'd probably say, you know what? I really love the fact that you have an opinion, and we are going to take that into consideration when I work this out with mom and dad.
Exactly. So awesome. Well, good. Yeah, and I think that's all the questions we have today for all our viewers. Chris, is there anything you wanted to add on your behalf in general about what you recommend, why people should consider this again, for those of you that are just catching up with our session today of how to protect your minor children?
Yeah. So I guess just a quick wrap up would be simple. And that is, everybody has opinions about literally everything. And so parents are going to have an opinion. Whether they agree on it or not is not important. Each parent's going to have an opinion about who would raise their children in the event of a tragedy of loss of mom and dad. And instead of leaving that to chance, even so I know it's an incredibly remote chance that both parents pass away, there is still a chance. Instead of leaving that whole thing to an undisclosed or undecided format, it's better just to prepare a simple will, get it done by a lawyer so we know it's done correctly and will be held up in court. And then your wishes as to who would raise your children in the incredibly unlikely event of this tragedy, it'll be settled.
Great. Well, thank you for the recap. I couldn't agree with you more. And I think that, for the viewers, I hope that you learned something. I always say, when you started this, from when you ended this, that you know something today that you didn't know when you started, because one of the big things is that everyone underestimates the power of these documents. These legal documents really, really do matter. And like Chris said, you want to make sure that they're done properly. You do not want to go on LegalZoom. I'm sorry to talk about LegalZoom, but just an example, you don't want to go online to just get any sort of will, because some of these wills do not have the proper verbiage or the proper information that really does protect your family in the long run. And so really consider this for your children and for your legacy, because that is all you have to protect. So you do have a say while you're still living, and please make sure to consider this for your minor children and minor adult children as well. Disabled adult children really is a big topic too. That could probably be a topic in itself, Chris. Maybe we cover that next time. But where do the viewers contact you, Chris, if they want to get in contact with you, find out more about your services and whatnot?
The best place to learn all about me and to get a hold of me is my website. Here it is right on the page, nudo.net. Text or call the phone number on your screen. Also, Google. Put in Attorney Christopher Nudo, and Google has plenty of information about me that you can look, research, and get to know me further.
Great. And Chris, out of curiosity, for those of the viewers that are maybe hesitant to leave their homes because of the pandemic, or perhaps see it as a barrier to what they're trying to achieve, do you offer virtual consultations or phone consultations that are not in person?
Absolutely. Absolutely. We use all types of audio, video media, and we also do the simple phone call. It's amazing. We don't always have to look at each other, although it's kind of fun. A simple phone call consultation gets the job done. And so my motto is whatever it takes to help the client get their job done.
Absolutely great. Well, I'm happy to hear that, because I also am offering them, because, time and time again, we do have clients that are looking for free consultations with both Chris and I offer from the safety of your own home. You can always come in person if you'd like. If you want to meet us, you can definitely meet us. We'll have our masks on and plexiglass and sanitizer, but we'll meet you. And so just keep in mind that we are offering different types of consultations, because everyone has different needs, and we are happy to accommodate that. You can learn more about me as well on my website, www.garcislawfirm.com. And as always, you can text or call the phone line that we have. Office line is 773-373-9592. Click there just to find out more about that. So as always, I want to thank our viewers, the supporters, the people that watch Pink Mike Legal Confessions every week. I know who you are. Thank you so much for your support. And you can always check in here on my Facebook page to get the most up-to-date videos of what we covered. And it is good tips for you moving forward in your life. As I always tell you, I cherish the opportunity to earn your trust and to work with you on a plan that makes sense for your future and for your legacy. We meet here every Tuesday, 2:30, Facebook Live for Pink Mike Legal Confessions. And like anything in life, it is always worth it to plan for your family. And this takes time. And so make sure that you leave time for yourself to do this. And again, a simple phone call is free. We would encourage you to reach out to discuss with us how we can best help you, and we would love to speak with you. I invite you all here to come back and tune in to Pink Mike Legal Confessions on Tuesday at 2:30 p.m., and we will be covering a new topic, which you'll have to stay tuned because I don't want to tell you yet, but it's going to be a new topic. It's going to be very interesting. And by the way, this is Central Time for anyone that is wondering. So invite your friends, invite your family, invite anyone that this could be relevant to. Please share this page. It doesn't take much to share it. Just click it, because people do want to know this stuff, especially us young parents. We do not always have the means or the resources available to us because we don't know where to turn. So social media, everyone's on it. Make sure to share it, and people will be happy that you did. So we see you again here next week. Thank you, Christopher Nudo. As always a pleasure to have you on the show. And if you need anything, you always can call us. Take care and be well. Thank you.